Welcome to today's Bob Benny Wealth Management webinar. Today is what? Today's August the 18th, Thursday. It's noon. Anyway, thank you for showing up for our webinar. Our topic today is 5 major estate planning mistakes and how to avoid them. And go ahead and cite a few basic estate planning facts, Jesse.
Sure. Well, first, if you guys have any questions while we're going through everything here today, there's a box at the bottom of your screen where you can type those in, and we'll go over all of those at the end here. But to get started, some basic estate planning facts that are important and interesting to know. Only 58% of Americans between the ages of 53 and 71, so that's technically the boomer generation, actually have estate planning documents in place, whether it's a will or a trust. The probate process can cost up to 10% of an estate, and we'll go over exactly what that is. But basically, when we're talking about an estate plan, we're trying to avoid probate, and we're trying to make sure that your assets get distributed according to your wishes. Those are the main goals of an estate plan. The probate can also take anywhere from several months to over a year or years.
To probate a will, or to probate if you don't have a will. So want to make a point here that if you have a will and all you have is a will, you're still going through probate. Probate is just a letter to a will is just a letter to the probate court.
So 64% of American adults who work with financial advisors have actually never discussed their estate plans with their advisor. That's something that we try to avoid here. That's one of the main foundational things that we like to make sure all of our clients have in place is an estate plan. Super important. Lastly, 35% of American adults say they have personally experienced family conflict or know someone who has as a result of not having an estate plan or will in place. So when there's not clear instructions and one or both parents pass away, things kind of come out of the woodwork that can be unexpected, even in families that are close-knit families.
Yeah, and I've had that in my experience of 27 years in this business and over 20 years of helping people with estate plans. It sometimes, the families that think they're very close and everybody gets along great, if they don't have things in place and have a defined instructions, there can be surprises and issues. So,
all right, so to get right into the mistakes that we want to try to avoid, the first mistake is thinking a will is enough. So like we said earlier, the two main reasons for having an estate plan in place is to make sure that your assets get distributed according to your wishes, and also to avoid probate. A will only does one of those things. A will only is instructions for distributing your assets, but it doesn't avoid probate at all. It's actually just a letter to the probate court. So you're already in probate if anyone's even looking at your will.
And if you don't have a will, your estate is going to, the state of Nebraska or any state has a will for you. It's called Interstate Succession. And Jessie has a slide here that she's going to show about how interstate succession works in Nebraska if you don't have a will. And so depending on how what your situation is, and Jessie will go through a few of these and explain to you how it works in interstate succession in Nebraska.
So if you are married, but you don't have any children and your parents aren't still alive, all of your assets are going to be distributed to your spouse. Now, that's probably what a lot of people might have in their will anyway in this type of situation. But if you go down to the next situation where if you're married and you have children with your spouse that you're married to at the time of your death, the first $100,000 of your assets are going to go to your spouse. And then 50% of what's left over is going to go to your spouse. But 50% of that remainder of what's left over is also going to be split evenly among your children. So for a lot of people, what their actual wishes are probably going to be is that if they pass away, their spouse gets all of their assets so that their spouse gets to live off of everything for the rest of their life. And then once they pass away, everything gets split between their children. But that's not how it goes with Nebraska state law if you don't have a will or a trust in place.
Just to kind of do the math, if you had a $500,000 estate, let's say, and you pass away, $100,000 goes to your spouse, that leaves 400,000. Half of that, 200,000 goes to your spouse, and 200,000 goes to the kids. So total of 300 ends up to your spouse, 200 goes to your kids. And like Jesse said, in many situations, that's not what your goal is. And then there's also a number of other different, we won't go through all the details, but of every possible situation for interstate succession. But rest assured, it's probably not what your intentions are. And so that's why you need to have an estate plan to say where your assets go when you and your spouse die, and so that they go to who you want, when you want, and how you want. That's what you want to do with an estate plan.
And so at the bare minimum, you are going to need to have a will, but what's going to be much better and more efficient so that you can have things distributed according to your wishes and also completely avoid the probate process is having a revocable living trust in place.
Right. And for that, we have a handy visual aid. Let me pull my visual aid out here. And the interesting thing about this visual aid in our camera is I have to write on this flip chart backwards because of the way the camera works. So let me kind of try drawing how a revocable living trust works. You create this trust. And I'm going to write the word trust backwards here, or try to write it backwards. So here's your trust. My wife and I have a trust, and most of our clients have a trust. But we are, Bob, and my wife's name's Angela. So we're the trustees. So I'll abbreviate that, trustees. We're the trustees and the beneficiaries as long as we're alive. That's Bob. And I'll just abbreviate her name, and Ange. Yeah, that worked, right? Okay, so we've created this trust, and we have 4 children. There are beneficiaries, even beneficiaries, and I won't write their names, but here's how stuff's going to go after we pass away. In the trust, we've named a successor trustee after both of us are gone. The successor trustee is our oldest child, which is Jesse's older brother. Trying to write his name, Jake. Okay, so Jake doesn't have any control over anything. He's not involved whatsoever until Bob and Angela pass away. Because if Bob passes away first, Angela is still the trustee, still the beneficiary, everything's still the same. When Bob and Angela both pass away, Jake becomes the successor trustee. The successor trustee, his job, or the successor trustee's job, is to manage and distribute the trust according to our wishes written in the trust. In our case, it's just, it's when the kids reach certain ages, they get their money. For a lot of people that have kids that are plenty old enough, they just get it all outright, but it's all okay. You can do whatever you want in a trust. Then you also, after this trust is created and these people are named and the beneficiaries are named, we have all of our titled assets titled into the name of the trust. For instance, like our home, it's titled in the name of the trust. Our vehicles, titled in the name of the trust. Our bank accounts, titled in the name of the trust, or the bank accounts have beneficiaries on them that the trust is the beneficiary, and we'll talk about that a little bit later. But just for instance, how this would work when we pass away is our successor trustee, Jake, can go to the bank and show them a copy of our trust and a copy of our death certificates, and basically with that takes over our bank account. He can then sell our different assets that are titled in the name of the trust, put the money in the bank account, divide it by 4, and write himself and his siblings each checks distributing the money. It's not quite, but almost that easy. And it avoids the probate process, which we're going to talk about a little bit in a minute too. Now, one thing I want to point, should I point out about the IRAs now?
We're
Or
gonna
wait.
go over that at a later point.
We'll go over the IRA. So IRAs don't go in your trust. And we'll explain that in a minute. Is that all I need to write backwards on my chart?
Yes.
Okay.
Yep.
All right. Good.
All right.
So we got
So
that taken.
to reiterate, mistake number one is thinking a will is enough. So only having a will and not having a revocable living trust.
What's mistake number two?
Mistake number two is having a trust, but naming a corporate trustee as your successor trustee instead of a family member.
Corporate trustee, that sounds kind of scary and expensive.
So it can be. So a corporate trustee would mean when you and or your spouse pass away, instead of having a child or a
One of the
relative named,
beneficiaries or a
one of the
trusted
beneficiary
friend or
names.
whatever.
You would have a bank, an institution, or a trust company named, and they're going to charge a fee to handle the trust assets and distribute them according to the trust document. And so that's usually between 1% and 2.5% of the assets value per year.
And then they charge you just distribution fees and all kinds of other kinds of fees. And they don't have the disadvantages of a corporate trustee. There's lots of disadvantages. They charge a fee. A beneficiary is probably not going to charge a free fee because they're a beneficiary. And you can even name in there if you wanted somebody that you wanted your trustee to get a certain fee for doing this, which it isn't a whole lot of work. You could name that, you know, my son Jake gets $5,000 for being the successor trustee. We're not giving him anything to be the successor trustee. He's going to get a quarter of everything your mom and I have anyway. So that's how most people do it. But a corporate trustee is going to charge a fee for managing the trust, a fee for distributing the trust. They're going to take over your financial accounts. And if you think about it, they're not going to have your beneficiary's best interests at heart as much as a beneficiary would. So we only recommend using corporate trustees for successor trustees of trust as a last resort. If you just don't have, if your kids are incompetent or not trustworthy and you don't have a trusted friend or whatever, then maybe you use a corporate trustee. But we help people try to figure out, if possible, who they could name as a successor trustee other than a financial institution or a bank or a trust company.
Okay. So mistake number three is having a trust. Again, having a trust, but not doing it right. So having a trust, but not correctly titling assets in the name of the trust to make it effective.
So a trust is useless for avoiding probate if your assets aren't titled in the name of the trust. Because the way something ends up in probate, whether you have a will or a trust or whatever, is how it's titled. If Bob Benny buys a new truck and titles it in my own name, and then I die, then now we have a titled asset titled in the name of a dead person. That triggers probate. That trust can't be touched. Or I mean, that vehicle can't be taken care of, can't be given anybody, title can't be changed, can't be sold, anything until it goes through the probate process. And so the different kinds of things that you need to have titled in the name of your trust, anything titled, like real estate, farms, houses, rental homes, that sort of thing. In our case, we have companies. We have an LLC that owns the building that we're housed in here. And we have an S corporation that is what Bob Benny Wealth Management Incorporated is. Well, the owners of the LLC and the S corporation originally were Bob and Angela Benny. Now it's the Benny Family Trust. And so everything that's titled is titled in the name of the trust. Vehicles, non-retirement investment accounts, bank accounts, brokerage accounts that are non-retirement accounts. All those kind of things need to be retitled into the name of the trust in order for it to be able to be transferred to whoever you want without going through the probate process.
And something we advise people to do that have, say, like checking or savings accounts at the bank that might be like a joint account is you don't have to change the name on that to the trust, and you would have, because doing that, you would have to get a whole new account number, and a lot of people have automatic payments that come out of that, have to get new checks, things like that, that would make it kind of an inconvenience. Instead, you can put what's called a transfer on death or payable on death, TOD or POB, and there's just a POD, there's a form at your bank that you can get where you can make it payable on death or transferred on death to your trust. So you're basically putting the trust as the beneficiary on the bank account.
Right. So what's mistake number 4, Jesse?
Mistake number 4 is not having proper beneficiaries on your retirement accounts. So any retirement account, whether it be an IRA, a Roth IRA, or a 401k, you can't title that in the name of a trust. It has to be titled in your name. But you're going to want to name beneficiaries and make sure that those are updated properly to reflect what you have in the trust. So if you're...
I'm going back to my visual aid. So if your IRA, I'll just call it an IRA, and I have to write that backwards, right? Doesn't look backwards to you, but this is the magic of the TV. So your IRA is outside of your trust, but it has beneficiaries on it too. Typically, most people have their spouse be their beneficiary, and then their children after they're gone. And so, it would go like this to these same people over here after both of us are gone. But you don't want to name, in most cases, you don't want to name the trust as the beneficiary of the IRA. And the reason is because of the tax consequences of this IRA. Remember, this IRA has been growing tax deferred, getting bigger and bigger and bigger, hopefully. Tax deferred. If it goes to a trust, if the trust is the beneficiary, then the trust, that's a taxable event. And all the taxes on that IRA have to be paid at trust income tax rates, which are higher than most individual income tax rates. So that's one thing. The other thing is first, if a spouse is the beneficiary of the IRA, they just can turn it into their own IRA, and they don't have to pay any taxes on it, and they don't have to take any money out and pay taxes on it until
they're 72 and a half.
Until they're 72. If it's kids, they have a 10-year rule. And so these kids, if they inherited me or Angela's IRAs, they have 10 years for not, whoops, I wrote that backwards. Look at that, Jess. I'll have to do it right. 10 years. I'll just do 10 anyway. So they have 10 years to take all the money out of the retirement account. They don't have to take it out evenly every year or anything like that. They could, let's say they're not retired yet and they don't need the money. They want the IRA to keep growing as long as they can. They can wait until the day before the 10-year anniversary of death and take it all out then or whatever. But we help people figure that out. We help our beneficiaries figure that out on when the best time to take it out to minimize the overall taxes for the beneficiary.
Okay, and then the last mistake number 5, is gifting investments, whether it be real estate investments, property,
we call it capital assets,
or financial investments to your heirs before you actually pass away.
Right. So there's a concept called stepped up basis with capital assets. And if I have something that I bought, a capital asset, let's say a piece of real estate, a farm that I bought for $50,000, and it grows to $250,000. If I sell it, I have to pay capital gains taxes on it, right? If I sell it before I die. If I gift that farm that I paid $50,000 for to my kids before I die, their cost basis on that capital asset, whether it's a piece of real estate or a stock or whatever, is the same cost basis I had. So as an example, let's say there's this stock that I have. I paid $50,000 for it. Now it's worth $250,000. let's say that the day before I die, I give it to Jessie, gift it to Jessie. Her cost basis is $50,000. If she sells it whenever, right away or right after I die, she has to pay capital gains taxes on the gain from 50 clear up to whatever, 250,000. If instead she inherits it in my estate, the cost basis of 50,000 gets stepped up to the value on the date of my death. And then when she sells it, she only has to pay taxes on any gain from the value on the date of my death to when she sold it, which if she sold it right away, it'd be the same. So, you know, in this example of a $50,000 cost basis now worth 250,000, if it was gifted and the capital gain would be 200,000, 20% of that's $40,000. If instead it was transferred in the estate, there's no tax on that $50,000 to $250,000. And that's a big thing that people do, because they start thinking, well, you know, the kids are going to get this thing anyway, I might as well give it to them now. Well, they're going to get your cost basis. So it's something to consider if you want to maximize the amount of money that the kids get and minimize the amount of money that the IRS gets, which is pretty important.
Absolutely. So we're going to go over any questions here in a minute. So if you have any that you haven't typed in yet, now is the time. But real quick, we're just going to review the 5 major estate planning mistakes to avoid. So the first one, again, is thinking that a will is enough and not having a revocable living trust.
The second one is having a trust, but naming a corporate trustee like a bank or a financial institution instead of a person, particularly the best is one of the beneficiaries.
The third is having a trust, but not correctly titling assets to make it effective.
Number 4 is not having the proper beneficiaries on your retirement accounts. You need to have primary beneficiary and then contingent beneficiaries in case the primary beneficiary is already passed away at the time of your death.
And lastly, number 5 is gifting investments, whether it be property or financial investments, before your death.
Right, so that you can avoid those unnecessary capital gains taxes on them. So I've been helping people with estate planning for over 20 years. And it's as a result of, frankly, seeing clients not have things set up right. Because our goal is to, as at Bob Benny Wealth Management, our goal is to help manage your investments, help manage your wealth, not only while you're alive, but also help to transfer it in the most efficient and effective way to your beneficiaries where you pass on, or when you pass on. So I've been helping people. I've helped hundreds of people create revocable living trusts. And the way that we do this now is you just come in the office. It's a 3-step process. We get online with the big screen that we're looking at that I guess you can't see unless we turn the camera around, but we get online and we get on a website called LegalZoom. And you may have heard LegalZoom advertised on the radio or TV before. And it's a service with lawyers that helps people create their own legal documents, like wills and trusts and corporations and all kinds of stuff like that. And so we help you create your own revocable living trust. Trevor helps me help you. And Trevor, by the way, is Jesse's husband that also works here. But we help you create your own revocable living trust. We don't charge anything for that. LegalZoom charges you for your trust for a couple, for your trust and all the ancillary documents that you need, like powers of attorney for assets and powers of attorney for healthcare and a living will and all that kind of stuff for the whole estate planning bundle. It's in the ballpark of $450. We don't charge anything for that. You don't have to pay us anything. We just help you do that. That's a service that we provide. In lieu of paying us anything, we offer for you to make a voluntary contribution to my favorite charity, Royal Family Kids Camp, that I can tell you about at another time. But you don't have to make any contribution whatsoever. I said it was a 3-step process. The first step is to create the trust online in my office. in a couple of weeks, they send the documents to us and we review them and then call you and come in and we have a signing powwow and help you get signed and witnessed and notarized all of your documents. And then the third step is to retitle the assets into the name of the trust. So they're going to go through the probate process, and we help you with all of that. And it's just a service that we provide at Bob Benny Wealth Management, and we'll help you and answer any kind of questions you have along the way. And we've gone through the whole process with lots of clients now where they've created trusts, they've passed away. We've helped their kids at no charge to settle their trust and distribute it to the beneficiaries. And that's just part of our services that we do.
Absolutely.
So let's answer some
Looks
questions.
like we've got a question here.
Yeah. It's showing up backwards. Yeah, well, hopefully we fixed that. Maybe anyway. Thank you, Clayton. But anyway, we thank you for attending, and we just want to help you and help your friends and family. And if you have any questions, you can email bob@bobbenny.com or jesse@bobbenny.com, and we'll answer your questions or call you or whatever you want. If you have any friends or family that that you think would benefit from this webinar, it's going to be available on our website in a few days.
bobbenny.com. And we
Yeah.
also put them all on YouTube, so
YouTube.
you can help us go viral.
Yeah, we've gone viral on some of our webinars.
That's not true, but sort of.
Well, we had hundreds of views. So anyway, thank you for coming or for attending the webinar, and hope you have a great day the rest of it.
We've got one last question.
Oh, one last question.
That we're going to answer real quick. Can you use TODs on titles to vehicles and real estate instead of a trust?
You can't do it on vehicles, but there is a way of doing it on real estate. We don't usually do that. We usually just retitle the real estate in the name of the trust.
Okay.
But anyway, thank you for the question. If you have any other questions, feel free to call the office at 421-2626 or email me or Jesse at bobbenny.com. And thank you very much and have a blessed day.
Thank you.